it's okay. Part-time judge and an advocate solicitor here in Scotland who's going to talk to us about interviewing children.
For those of you who are not familiar with the set-top system in Scotland, I should perhaps start by explaining that Scotland has a distinct and separate legal system from that in place in England and Wales, and it's a legal system which we Scots are very proud indeed. So when there's been reference at various points to this is the situation in the UK during some talks, that might be a misunderstanding, because although there are some matters that are UK wide matters, most matters are regulated these days by the Scottish Parliament under devolved powers. As David explained, I'm an advocate in practice at the bar in Scotland, a barrister. I'm also a part-time sheriff, just to explain something about what that is. In relation to criminal matters, we have 3 levels of court. At the lowest level is the district court, at the middle level there is the sheriff court, and at the highest level there is the High Court of Justiciary. So the sheriff has the middle range jurisdiction. The sheriff also has a very wide jurisdiction in Scotland in relation to both civil and criminal matters. In criminal matters, the sheriff can sit on his own, listening to trials and dealing with summary crime, or can sit with a jury with the sentencing power of 5 years imprisonment. So that tells you something about, I hope, what I do and something about the system. Reflecting on what I was going to say today, I thought it important perhaps to explain to people that I've also acted between about 2003 to 2008 as a prosecutor in the High Court in Scotland, prosecuting the full range of the most serious crimes, murder, rape, all sorts of very serious offences. So I'm trying to bring that experience to bear on what I say about child interviewing, and I'm also going to bring my experience in practice, in private practice at the bar, to bear on these matters as well, as you will see. Of course, everyone will agree that the investigation and proof of crimes committed against children are matters that obviously raise issues of great sensitivity and importance to any civilised culture. These issues are constantly at the front of the public conscious. They necessarily generate sensation and media interest. This reflects, no doubt, the normal and natural human reaction to criminal exploitation, abuse or ill treatment of children. Sometimes in the courts, we experience something of the glare of publicity when things go wrong. Everyone wants to see what they perceive as justice having been done. When that important expectation is not met, then questions are asked, and rightly so. Reflecting on my experience as a prosecutor, I've personally had the adverse professional experience of prosecuting a criminal trial in the High Court, which featured 7 alleged victims who were all children. We call alleged victims in our criminal proceedings complainers. In this particular case, the 7 girls had each made allegations amounting to sexual misconduct against a man from Falkirk, where they all lived. The police discovered an odd situation in which these young girls, aged about 9 to 12, would regularly frequent this single man's house. He was about 60 years of age. He gave them sweets, alcohol, cigarettes, and you've probably heard of other cases with similar sorts of background, and indeed I've heard reference to these sorts of circumstances in some of the presentation tonight. In this particular case, the various charges on the indictment required essentially that a course of conduct required to be inferred from the evidence, with each child speaking to various separate incidents involving only herself alone and the accused. We have strict rules about corroboration in Scotland, but for those of you who are informed about them, the case required the application of the Rooy doctrine. Unfortunately, one or more of the girls were unsatisfactory witnesses in that they appeared to say different things, at least in some respects, in their evidence led by me, by CCTV link, to the court when compared with what they had said previously in joint investigative interviews in excess of a year beforehand. It was also clear that at least one of the girls had learning difficulties to some extent. As a result, the case didn't get to the jury. There's a procedure in Scots criminal law whereby the prosecution case can be challenged on the basis of a no case to answer submission at the close of the Crown case. That's what happened. The whole case fell apart in a sort of domino effect manner. The accused was acquitted on all of the charges. You might be wondering, what's the purpose in disclosing this bitter old war story from the courtroom? I reflect on it and it leaves me wondering what might have been. Were the interests of justice properly served in that case? From a human perspective, what will become of some, or perhaps all of the children as a result of their experiences at the hands of the accused, and also having given evidence in court with the result that was the case. It also leaves me wondering whether the case might have turned out differently, might have reached the jury and might have been found to be proved if there had been properly conducted video or DVD recording, joint investigative interviews with all of the complainants made at the earliest stage as soon as the complaints were made. Of course, I'm only highlighting a matter about which many of you present are acutely aware, with a sophisticated and mature understanding of the issues which require to be addressed and rectified to address a scenario such as this. I'm going to become a wee bit corny now and reflect on last year's ARG conference. I'm going to start off by considering my perspective as an advocate in relation to these matters pre-Stavern. I arrived at the ARG conference last year in Stavern, Norway, June 2010. I thought that I had a good grasp of the issues to be considered in relation to the forensic interviewing of children. I'm slightly unusual as an advocate in private practice because I seem to be continually instructed in cases in which issues arise in connection with the forensic interviewing of children. Indeed, a couple of months or so before last year's conference, I had had great success, I sometimes win cases as well, in very difficult circumstances in advancing my client's case in Edinburgh Sheriff Court in the case of S against FD, about which I'll say more. Pre-Stavern, as I've told you, I was also an experienced prosecutor who had seen many poorly conducted forensic interviews with children. Pre-Stavern, I can say that honestly, I thought that the interviewing of children in the forensic context was just such a difficult task that it couldn't be done well, and that was just something the system had to live with. I attended Michael Lamb and Phil Esplin's masterclass at Stavern. I learned about the NICHD protocol, about which there's been much talk in various of the presentations. I saw with my own eyes on video and DVD recorders, I think they were, that improvement really could be made. I saw with my own eyes the level of improvement that could be brought to bear on this most difficult, sensitive and crucial tasks. It made me realise on reflection that although I thought I a good, sophisticated, developed understanding as a lawyer of the issues. I was really operating on a knowledge threshold that didn't really understand the essential differences between a well-conducted interview and a poorly conducted one. I required to deconstruct my views and reconstruct. And to be honest, this came as a surprise to me. Lawyers like to think that they're the people who ask questions professionally and who know all about technique in that enterprise. Indeed, since the early 1990s, my own professional body, the Faculty of Advocates in Scotland, has invested considerable time and resources in the development of sophisticated training programmes in oral advocacy. But I've come to realise that the essential truth is that the forensic interviewing of children is a completely different enterprise from that which advocates do and do regularly. I've come to understand that the forensic interviewing of children is an enterprise which lies truly within the province of the behavioural psychologists. I've come to the view that other professionals who require to discharge difficult and important responsibilities in connection with the forensic interviewing of children, whether they're lawyers, judges, police officers, social workers, must, in my view, proceed with their tasks with a proper understanding of the knowledge and learning of the behavioural psychologists. I flew from Edinburgh to Torp near Stavern last year. Our Norwegian hosts were truly magnificent in their hospitality. There was even a lift organised from the airport, and Ellen is here. Ellen gave us the lift. There was another guy who was on my plane from Edinburgh who shared the lift. He was David Leroy. I'd heard of David. I had no idea who he was. I knew he was available for expert witness opinion in Scotland, but I was unsure of his area of expertise. But I can say from the moment that we met, we incessantly and passionately discussed issues related to the forensic interviewing of children in general, and in Scotland in particular. We had the luxury of a spare Saturday before the masterclass began. We used it to walk around the beautiful, exceptionally beautiful scenery of Stavern, to pop into various pubs, probably too often, have a few beers, and to continue to talk relentlessly about the forensic interviewing of children. Well, you might be reaching the stage where you're wondering, what's the point in this chummy wee story? The point's a very important one. It's crucial and based upon my direct experience at Stavern and since then. The effect of collaboration from different professional perspectives can be and must be dynamic in this difficult enterprise. The professionals involved must collaborate and must learn from one another. From my professional perspective, the essential ingredient for improvement is the scientific, proven, knowledge-based approach of the behavioural psychologists. In relation to any contentious issue in child interviewing, I can still hear Phil Esplin's regular comment, "Show me the data." It's this requirement for objective verification of methods by reference to research, or proof, if you like, which distinguishes the approach of the behavioural psychologists, or the memory men, as Phil continually referred to. I'm now going to focus on developments post-Stavern. Within a month of returning from the ERG conference, David and I, having regained our voices, had an article published commenting on the forensic interviewing of children in Scotland based on our collaborative experiences. The article is entitled "The Quality of Joint Investigative Interviews with Children in Scotland." It's published in 2010 Scots Law Times, page 133. The article, I think, for those who have read it, they would agree, is hard-hitting. It was not popular in all quarters. It seeks to highlight what we viewed as a serious systemic problem which is harming the welfare of children and the interests of justice in Scotland. It makes reference to relevant research. It referred to two recent cases, one from the criminal courts and one from the family courts in Scotland. The point in highlighting both cases was that in each case there were important issues arising from defective forensic interviewing of young children. I should say that the criminal case referred to in the article, in case anyone has read it, did result in the eventual conviction of one of three accused. I suspect that much of that was down to the fact that the complainants were accepted by the jury as telling the truth in their evidence, and no doubt it was to some extent as a result of the great skill of the advocate deputy who prosecuted the case. But the point about that case, for present purposes, was that it had been beset by difficulties and arguments arising from child interviewing issues which were, even if not avoidable entirely, were capable of being mitigated, in my view. The Scots Law Times article sought to emphasise that the essential prerequisite for improvement is the video or DVD recording of joint investigative interviews with children. Now, that won't surprise many of you, but it is a matter of regret to say that in Scotland to date, video recording of joint investigative interviews has not been routinely done. It seemed obvious to me, and to many others without, but it seemed obvious to me from the Lamb and Esplin masterclass that the video recording, the immediate video recording of forensic interviews with children was fundamental to deriving any meaningful assistance from the perspective of the welfare of the child. Without a video recording for a serious case to be proved, the one thing for sure is that the child has to come to court to give evidence. That's not necessarily the case if there is a properly conducted video or DVD recording of a joint investigative interview of a child in Scots law. Almost as concerning is the fact that without video recording, the development of the skills of interviewers in this challenging task of interviewing children is necessarily inhibited. There's nothing like a video review, for those who've done it, and I know some did it on the masterclass at the beginning of the week, to crystallise in one's own mind the need to improve. We all learn by our mistakes. Video review is used to great effect by my professional body in their advocacy skills training. I can well remember the humiliation of it all, being torn apart by an expert instructor while watching a video of myself cross-examining thin air. But we do learn by our mistakes, and that's important. I'm going to make some reference now to two Scottish cases that are relatively recent. The one that I referred to earlier on, that I completed before going to Stavern, that's S against FD, and another one from more recent times, last December, that was decided at Kilmarnock Sheriff Court. To summarise the facts of the case of S against FD as briefly as possible, they are as follows. The married parents of a girl aged 6 and a boy aged 2 separated amidst the mother's claim that their daughter had alleged that her father had sexually abused her. The child was questioned by her mother on the evening of the alleged allegation and again before visiting a GP. The child then participated in 2 joint investigative interviews with the police and social services in which direct and leading questions were asked. The children thereafter lived with the mother. The father was subsequently granted a court order for supervised contact with the children for 2 hours per week, but raised proceedings seeking unsupervised contact. The mother didn't wish the pursuer to have unsupervised contact unless there was a guarantee the children were safe from sexual abuse by him, and in turn sought an order to permit her to take the children out of the country to Spain. She was Spanish. During the course of the proceedings, the defender alleged that the pursuer had abused their daughter, but on other occasions, albeit her original police statement did not mention such abuse. That's a summary of the facts. I represented the father in the case. Slightly unusual background as well. The father was a South African anarchist who worked for the Bank of Scotland. It perhaps explains something about the financial crisis. The mother was described as a Spanish anarcho-feminist who associated her views with those of an extreme ultra-feminist called Valerie Solanas. I don't know if any of you know of her alleged work. Slightly unusual facts and circumstances, but the whole decision really turned upon the treatment, the forensic interviewing of a 5-year-old child. The case was determined by the senior sheriff at Edinburgh Sheriff Court, Sheriff Nigel Morrison, QC, very experienced sheriff who had direct experience of acting in circumstances that led to the Orkney inquiry in 1991 in Scotland, which I'm not going to explain, but which some of you will know all about. The sheriff determined the various facts, and then at paragraph 65 of his judgment, he set out matters of concern. He wrote, "I cannot leave this case without commenting on 6 matters that emerged from the proof. The interviewing of Z." He says, Z was interviewed at the first joint investigative interview on 2nd October 2008 by DC Johnson and Miss Black. The second joint investigative interview was conducted by Miss Black and PC Purnell on the 10th of December 2008. Miss Black did most of the questioning at each interview. Before and after the second interview, Miss Black carried out direct work with Z. Miss Black said her direct work was carried on without reference to the police, although she thought they knew about it. The sheriff goes on to say, "I was not impressed with the joint investigative interviews. I considered the second one to be one of the worst I've seen. Dr. Robson, who was a child psychologist instructed for the mother in the case, considered the interviewing of Z to be worse than the interviewing of children that led to the Orkney inquiry in 1991. Because what was done here was so deliberate. It alarmed her that all these years later, there was such direct questioning of a child because she was not saying what the interviewers wanted to hear. What the interviewers did was against 20 years of guidelines." The sheriff goes on to highlight what he describes as a catalogue of what was concerning about the interviewing of and direct work with this 5-year-old girl. First of all, he details the joint investigative interviews were not mechanically or audio and video recorded. He says, "I think it is extraordinary that as a matter of course, by 2008, joint investigative interviews of children were still not being mechanically recorded in Edinburgh." He comments on the fact that there are facilities to do that that were available, and he comments there is no excuse for it not being video recorded. Dr. Robson described the lack of video recording to be unusual nowadays. I have to say, that's not my experience. The sheriff goes on further to highlight in relation to the aspect of direct work that had gone on between the 2 interviews with this girl. Miss Black had no conception of the risk and damage her direct work with Z was doing in the investigative process. She was tragically unaware of the dangers of mixing investigative and therapeutic direct work. Miss Black saw nothing wrong with it. There was no question, he says, of Z having volunteered unsolicited information. At one point, Ms. Black even suggested in evidence, this is a senior practitioner, social worker, that Z could have disconfirmed, the 5-year-old could have disconfirmed what was being put to her. There are various other concerning comments made by the sheriff that are essentially and dramatically, I suggest, critical of the interviewing of this little girl. I don't have time to detail, but you know, if you want a catalogue of how not to conduct a joint investigative interview with a child, read this case. I can provide you with a copy. The sheriff, indeed, was so concerned about the lack of refresher training, as well as the quality of these interviews, that he states at paragraph 70 as follows: I'm so concerned about the poor and damaging quality of the interview and the direct work done by Ms. Black, I will be directing that a copy of this judgment is sent by the Sheriff Clerk to the Director of Children and Families and to the Chief Constable. In my opinion, Ms. Black, DC Johnson and PC Purnell should not be permitted to interview children until they have been retrained. In relation to Ms. Black, I think she should also be removed from any child protection work until she has been retrained. Dramatic and concerning. No doubt most of you, if not all of you, would agree. I was going to refer to a second case, but frankly, I don't have the time. The second case really discloses matters along the same lines, although in a different area of Scotland, a different sheriffdom. And obviously what I'm highlighting for my purposes is that it doesn't look as if S against FD is a one-off. Both of these cases made sensational headlines. Now, sensational headlines were not what was sought, but it illustrates the point that these are matters of great public concern, and these are matters of great importance to all of us and to the public interest. I'm going to reflect just for the last part of my talk on what does the future hold for Scotland. Just now in Scotland, there is guidance in relation to the forensic interviewing of children. The guidance was issued by the Scottish Executive in 2003. It's good guidance. That's hardly surprising given that Amina Menon had a material part in its construction. It details and contains in an appendix a protocol type approach. But experience in the courts shows us that by and large, the guidance, although good, isn't being adhered to. In a sense, this has to be the acid test. Does practice hold up in court? And regrettably, the answer at present appears to be no. To date, there's a suspicion that the guidance has been viewed by some of those asking questions of children as only advisory. As we speak, the Scottish guidance on joint investigative interviewing of children is being revised. I haven't seen any draft. I can't predict what the final version will look like. However, this is my personal professional perspective. In my view, reflecting on my experience in cases, and also my experience of understanding what the behavioural psychologists say about matters, the new guidance, in my view, must be based on the NICHD protocol approach. This is acknowledged, as I understand it, to be the gold standard, validated by robust research. Anything else is likely to run the risk of falling short of that gold standard. The new guidance must take proper account of the views of the behavioural psychologists, in my view. In my view, the new guidance must require video or DVD recording of joint investigative interviews with children, consistent with the approach advised in the NICHD protocol. The new guidance, in my view, must be prescriptive in its instruction of interviewers rather than advisory. I say this because I have seen on DVD the positive results of strict adherence to the NICHD protocol. Literally, a police officer with the protocol in hand, systematically asking a young child to prescribe questions in the prescribed sequence. I also reflect on what I've seen in a 2009 paper entitled "Use of a Structured Investigative Protocol Enhances the Quality of Investigative Interviews with Alleged Victims of Sexual Abuse in Britain" by Michael Lamb and others, in which they summarised research which clearly demonstrated that the employment of the NICHD protocol produced significantly more effective results in the forensic interviewing of children when compared with other techniques. As far as I can see, if rapid improvement is the aim, which it must be in Scotland, the remedy, to my mind, is obvious. Any method other than the one which has been shown to be effective, to my mind, involves experimentation. It may or may not produce positive results. I, for one, do not think that in Scotland we have the luxury of time on our side to experiment. Of course, it's also likely that if any unvalidated, unproved approach is adopted, it will be tested in court cases against the gold standard. In my view, this is the worst case scenario of all. I say this because it would involve challenge on a case-by-case basis to the unvalidated approach. In conclusion, I don't want any listener today to think that insufficient value has been attached by me to the dedication and commitment of the professionals who have undertaken joint investigative interviews with children in Scotland. I know it's a difficult task. I know their value from my own experience as a prosecutor. I know of their dedication and commitment from my discussions with David, reflecting on his direct work with police professionals in Scotland. However, I respectfully suggest the proper and sensible way forward in Scotland is to properly train and equip these dedicated and skilled professionals with the correct tool for the task in hand. We only know about appropriate training and correct tools by reference to demonstrable verification research. It's my hope that the hosting of this important conference, at which many of the issues about the proper theory and approach to the forensic interviewing of children are properly understood, will assist us in Scotland to improve, and it's immensely encouraging to see Scottish professionals here actively participating, listening and debating the issues. We have dedicated professionals in Scotland. We also have the opportunity to develop the best approach in this enterprise, which is both crucial to the welfare of children and to the interests of justice. We must now take full advantage of this opportunity and the resources available to us.
Okay, we've got time for a few questions. Does anyone have any questions for John?
Is anyone awake? Self-explanatory. If anyone is interested in any of the material that I've referred to, and I would understand if you're not, because it's peculiarly Scottish, only applicable really to our jurisdiction, apart from the matters of general principle, I'm happy to furnish copies of the article I referred to or the case reports. My email address is up there.
Okay, thanks very much.